Rise. Please take your seats. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, CCJ Appeal number 15 of 2017, between Quincy McEwan, Seon Clarke, Joseph Fraser, and Seon Passad versus the Attorney General of Guyana. For judgment this morning. Can we have the appearances for the court, please? Thank you.
Good morning, Your Honors. Mr. Douglas Mendez leads, Mr. Nigel Hughes, Ms. Mishka Puran, Mr. Issa Buchanan, and me, Clay Hackett. On behalf of the appellant, I apologize for Mr. Mendez's absence this morning. He's currently before the industrial court involving a trial with the OWT and Patrician litigation.
May it please Your Honors, Kamal Rampuran, appearing with Ms. Kim Kite, Solicitor General, Deborah Kumar, Deputy Solicitor General, and Colleen Liverpool for the respondent, the Attorney General of Guyana.
Yes, good morning, Counsel. There were 4 different opinions in this judgment. The main judgment, and then there were much shorter concurring judgments by Justice Anderson, Madam Justice Rajnath-Lee, and Justice Barrow. I will read a summary of the judgment. This summary is not intended to be a substitute for the reasons which are set out in the judgment itself, nor is the summary to be used in any consideration of the court's reasons. Those reasons are fully set out in the judgment. The appellants, Quincy McEwan, Seon Clarke, Joseph Fraser, Seon Passad, identify themselves as transgendered persons. As a result, their appearance, mannerisms, and other outward characteristics are not consistent with society's expectations of gender normative behavior. In February 2009, they were arrested, detained, charged, convicted, and punished for cross-dressing in public, pursuant to Section 153, subsection 1, subsection 47 of the Summary Jurisdiction Offences Act. I will refer to that particular law as the impugned section. The impugned section prohibits every person who, quote, being a man in any public way or public place for any improper purpose appears in a female attire, or being a woman in any public way or public place for any improper purpose appears in a male attire. McEwan and Clarke were arrested on the evening of Friday, 6 February 2009, while awaiting transportation in Georgetown. McEwan was dressed in a pink shirt and a pair of tights, along with a black hairpiece. Clarke was wearing slippers, a jersey, and a skirt. They were transported to the Bricknam police station, where they were photographed and instructed to undress and then placed in a lockup. A few hours later, Fraser and Passad were also arrested and taken to the same police station. At the time, they were dressed in skirts and each wore a red and black wig. While in custody, Fraser made several requests of the police. He demanded that the police take a statement from him. He sought legal counsel and requested medical attention for injuries sustained during an earlier altercation. He also asked for a telephone call. None of his requests were granted. Instead, he and Passad were put in a cell where they met McEwan and Clarke, and that's where all 4 of them spent the weekend. Neither at the time of arrest nor at any other time during the weekend did they receive any explanation as to why they had been arrested and detained. It was only when they were taken to the Georgetown Magistrates Court on Monday, 9th February, they learned for the first time that they had been charged with the offenses of loitering and with the offense which I described in the impugned law. They all pleaded guilty to the cross-dressing charge, and McEwan, Clarke, and Prasad were fined $7,500, while Fraser was fined $19,500. Upon imposing the sentence, the presiding magistrate told them that they must go to church and give their lives to Christ. She advised them that they were confused about their sexuality and that they were men, not women. Sometime after the proceedings, before the magistrate had ended, the first to fourth named appellants held discussions with the Society Against Sexual Orientation Discrimination, SASOD. SASOD is a local human rights organization whose objectives include the cause against eradication of homophobia in Guyana and throughout the Caribbean, undertaking efforts geared towards constitutional reform of discriminatory laws against the LGBTI community. After these discussions, the individual appellants did not appeal their convictions, but they instituted constitutional proceedings along with SASOD in the High Court, alleging violations of their rights declared in various fundamental rights articles of the Guyana Constitution. These included the rights to be informed as soon as reasonably practicable, for the reasons for their arrest and detention, and their right to be allowed to retain and instruct counsel. They also contended that the impugned law was unconstitutional because it was vague, uncertain, irrational, and discriminatory. The vagueness and uncertainty, they said, related to the words, quote, improper purpose, unquote, and, quote, female attire, unquote, and, quote, male attire, unquote. They claimed that that law breaches several different articles of the Guyana Constitution. It is further argued that the sentencing remarks of the magistrate reinforced discriminatory treatment. The High Court judge, whilst upholding that the police had a duty to inform the individual appellants of the reasons for their arrest, held that the Constitution did not impose upon the police an obligation to enable an arrested person to retain and instruct counsel. The judge further denied the challenges to Section 153, that's the impugned section, and disagreed that that section was too vague and uncertain to be enforceable, and considered that it was the improper purpose that grounded the criminalization of cross-dressing in public. The judge, in addressing the issue of the religious admonitions of the magistrate, held that, at worst, the magistrate's statements amounted to mere proselytizing, but they did not constitute a hindrance to freedom of thought and of religion. The judge also held that SASOD had no standing and ordered that that body be struck from the proceedings. Each appellant was awarded the sum of $40,000 for breach of the right to be informed as soon as reasonably practicable of the reasons for being arrested. And the judge awarded the state $5,000 in costs to be paid by SASOD. The appellants appealed to the Court of Appeal, which agreed with the trial judge that the impugned law carried no taint of gender discrimination and dismissed the appellant's argument that that law had lost its status as an existing law because of several amendments since independence. In the view of the Court of Appeal, the substance and mischief targeted by the law remained unaltered, and as such, the law was saved from constitutional challenge by the savings law provision. On the vagueness point, while acknowledging that the expression, quote, improper purpose, unquote, is broad in meaning, the court pointed out that the use of that phrase was intended to capture a range of different situations, and that it was impossible for the draftsman to fashion with a degree of certainty all the various situations that it covered. Finally, the Court of Appeal dismissed the allegations that the magistrate's comments made during the proceedings at the magistrate's court infringed the appellant's constitutional rights, and the Court of Appeal made orders in relation to the breach of the right to be informed as reasonably practicable of the reasons for being arrested. The decisions of the Court of Appeal formed the basis of the appellant's appeal before this court, which was premised upon the same issues raised in the lower courts. The CCJ considered the alleged violations of the appellant's constitutional rights to equality and non-discrimination and freedom of expression. And the CCJ also considered whether the impugned law offends the rule of law. The court also considered whether SASOD was a proper party to the proceedings and the propriety of the remarks of the magistrate. In considering the constitutionality of the impugned section, the court first examined the historical context surrounding its promulgation as part of the vagrancy laws of the post-emancipation era. It was noted that many of these laws had been struck down in countries such as the United States because they had been ruled to be violative of the rule of law. The second preliminary issue considered was the effect of the savings law provision and whether the impugned law was an existing law, and if it was, whether it was therefore immune from judicial scrutiny because of the savings law provision. This was in fact a fundamental plank upon which the state defended the challenge to the constitutionality of the law. The CCJ noted that until its recent decision in Nervis and the Queen and Severin and the Queen, it had been the conventional wisdom that the Savings Clause completely immunized pre-independence laws from being held to be in contravention of the human rights laid out in the Constitution. The courts below adopted the conventional wisdom. The majority judgment reiterated that, quote, law and society are dynamic, not static. A constitution must be read as a whole. Courts should be astute to avoid hindrances that would deter them from interpreting the Constitution in a manner faithful to its essence and its underlying spirit. If one part of the Constitution appears to run up against an individual's fundamental right, then in interpreting the Constitution as a whole, courts should place a premium on affording the citizen his or her enjoyment of the fundamental right, unless there is some overriding public interest. This court was therefore not precluded by the Savings Law Clause from testing the impugned law for its compatibility with the Constitution. The court observed that the Cooperative Republic of Guyana is an indivisible, secular, democratic, and sovereign nation, and its most precious civic values are laid out in the country's constitution. Article 149, sub-article 1 of the Constitution protects the people of Guyana from discrimination and states that no one is to be treated in a discriminatory manner by any person acting in the performance of the functions of any public office or authority. The Constitution further provides that the state shall not deny anyone equality before the law. The appellants contended that cross-dressing law infringed these constitutional guarantees because it is rooted in gender stereotypes of how women and men should dress. They argued that the section treats transgendered and gender non-conforming persons unfavorably by criminalizing their gender expression and gender identity in violation of their constitutional right to equality and to protection against discrimination. In agreeing with the appellant's arguments, the court stated that at the heart of the right to equality and non-discrimination lies a recognition that the fundamental goal of any constitutional democracy is to develop a society in which all citizens are respected and regarded as equal. Article 149 gives effect to this goal. The court concluded that although it is true that cross-dressing is practiced by persons of several types of sexual orientation, the impugned law has a disproportionately adverse impact on transgendered persons, particularly those who identify with the female gender. It infringes on their personal autonomy, which includes both the negative right to not be subjected to unjustifiable interference by others and the positive right to make decisions about one's life. The lower courts were therefore wrong to hold otherwise. The CCJ also found that the impugned law infringed the appellant's right to freedom of expression as guaranteed under Article 146 of the Constitution. This article similarly allows for laws to be enacted that are reasonably required in the interests of, among others, public order, public morality, public health, and the rights and reputations of other persons. A person's choice of attire is inextricably bound up with the expression of his or her gender identity, his or her autonomy, and his or her individual liberty. This choice is an expressive statement protected under the right to freedom of expression. No one should have to live under the constant threat that at any moment, for an unconventional form of expression that poses no risk to society, he or she may suffer such treatment. In addressing the issue of the local standard of SASOD, the court stated that the courts below did not appreciate that SASOD, given its mandate, had a real and genuine interest in the legislation under challenge, since that legislation could be applied in future to any member of the general public, including other members of SASOD. As such, in constitutional challenges, the court held that courts should adopt a liberal approach in affording standing to individuals and entities. The CCJ further noted that when litigants appear before the courts, they are entitled to a fair hearing before an impartial tribunal in accordance with Section 144 of the Constitution. Judicial officers must therefore safeguard against any inherent prejudices they may have and not use the bench to proselytize or to express any stereotypical thinking. Secularism is one of the cornerstones upon which the Republic of Guyana rests, and the remarks made by the magistrate were inappropriate and unacceptable. The Honorable Mr. Justice Anderson, in a separate opinion, stated that the appeals must be allowed because, in purporting to criminalize the act of cross-dressing for an improper purpose, the impugned law is an unconstitutional extension of criminal liability. Justice Anderson agreed that the purported offence is impermissibly vague and that the section confers unacceptably broad discretion on state officials to arrest and charge at will. He, however, added that the section is unconstitutional in that it seemingly purports to criminalize intentions or states of mind, which, in his view, is not a competence constitutionally within the realm of the criminal law. Justice Anderson stated that our jurisprudence properly accepts that intentions by themselves are not constitutionally the proper subject of the criminal law. The Honorable Madam Justice Rajnath Lee, in her separate judgment, elaborated upon the appellant's argument that the impugned law is so vague that it renders the law a violation of their right to the protection of the law guaranteed under Articles 40 and 144 of the Constitution. She noted that criminal statutes which are vaguely drawn are inconsistent with the right to protection of the law. Penal statutes must provide fair notice to citizens of the prohibited conduct. They must not be vaguely worded. They must define the criminal offence with sufficient clarity that ordinary people can understand, and they should not be stated in ways that allow law enforcement officials to use subjective moral or value judgments as a basis for enforcement. In his separate opinion, the Honorable Mr. Justice Barrow stated that these laws belonged to a different time, and that the offences created in the Act were in tune with the poor laws of the Victorian era and intended to keep the dispossessed and depressed under control. The objective of these laws was not to promote fairness, social justice, or equality. The specific offence targeted homosexual conduct. Justice Barrow addressed the state's argument that the judiciary should be cautious not to succumb to deciding on issues of social policy and legislative reform. He stated that it is not every law that the executive must feel obliged to defend against challenge, especially where the Constitution affords aggrieved persons the right to make these challenges. The government must acknowledge on its own accord when a law, especially one like the impugned section, has long passed its sell-by date and serves no social or legal purpose. Having regard to all the opinions expressed, the court allowed the appeal and declared that Section 153, subsection 1, subsection 47, violated the appellant's right to equality and non-discrimination and to their right to freedom of expression. The court held that the section is unconstitutionally vague and offends the rule of law. The court ordered that the section be struck from the laws of Guyana and awarded costs to the appellants in this appeal and in the courts below.
Court rise.